It's great to have you all here. This is our final event in the Quinnipiac Yale Dispute Resolution Workshop for this year. But I encourage you to give me your email list, and I'll make sure to, your email, be sure to put you on our list for next year's series, which again should be a very good group of people coming to our campuses at Quinnipiac and Yale to speak about various forms of dispute resolution. And we're very proud of the record that we have and the group of people we've been able to draw to campus to share their ideas and their work with us. And today is very special in that sense. We have Chuck Howard, who's a partner at Shipman and Goodwin in Hartford with us, who I think can fairly be said to be one of, the central people in the country working on the topic he'll be addressing today, ombudspersons, ombudsmen,
ombuds, whatever.
Ombuds. Chuck's experience with litigation is so wide-ranging, it's probably hard to come up with a subject in intellectual property that he has not touched in his litigation, but it goes beyond that because he works in the public sector. He's represented the state of Connecticut, quasi-public state agencies, municipalities, and business clients dealing with those entities as well. He has a national practice in representing organizational ombudsmen in universities and in the private sector. He was the chair of the litigation department at Shipman and Goodwin for 15 years, right, from 85 to 2000.
Seemed like longer.
And he is an arbitrator with the American Arbitration Association. So he's spoken very widely, published very widely, and the list of experience that he has in litigation is pretty impressive. So we're very, very grateful for you to take the time out of your schedule to speak to us. Thank you.
Well, thank you very much for having me. It's a delight to be here. And I did look at the other people who've come to the programs. I don't know how many of you have made it to all of them, but it was a pretty impressive list. I did try to make it to some. Unfortunately, my schedule conflicted me from all but one, but it really looks like a great deal. So I have it on my list. I want to be on your email list, and hopefully I will see you next year at some of these again. The topic that I have, I think, may be a little different. I mean, not only am I a non-academic compared to the academics that you've had, but my topic is not so much about ADR theory or techniques or that sort of thing. It really is kind of a more fundamental issue, which is observations that I've made about structure of our organizations, especially our large organizations like universities, companies, many of which are multinational now, or virtually all of which have people from a whole variety of different cultures coming together. And with that comes conflict, and with that comes the need to manage disputes. And so really it's more of a structural observation of what I think would be a really good thing for most of our major organizations to have. And it's really how they can help people report or resolve conflict that arises in the workplace or in the interaction in large organizations. And I don't really separate the dispute kind of person A to person B from questions of misconduct, or somebody A is observing something that's wrong, because I think lots of people don't see them as separate, or there's a continuum of that. So one of the things about the ombudsman role, at least as I've envisioned it and have studied it, is that it's pretty capable of dealing with both of those. So here's what I thought I would do, and we've got a pretty small group here, and apparently we're being filmed, and so that's why I have the podium, but I'd like to have this be more of an open discussion. And I don't know that much about most of you. I know some of you are lawyers. I know at least one person is in law school. I know we have a mediator or two. I don't know about the rest of you, but what I'd like to do is give you 15 or 20 minutes of little background, kind of introduction. I can describe how I got involved in this if you'd like. but then open it up, because there really are a whole variety of issues that may be interesting issues, from examples of how ombudsmen work, legal issues dealing with notice and imputed notice, issues like how do you protect confidentiality, some of the history or some of kind of the status of all of this, and all of those are fair game. I did write a book, and that's what kind of brought me here. I think you have to be nuts to try to write a book. I now know that. I didn't know that when I started. But it was truly a passion. And when I sat down to say, okay, I think I'm really going to do this, I was very simplistic about it. I said, okay, let's, what should be the organizing theme here? And I went back to the kind of basic questions, what, why, and how. And so that's really what I did. I tried to describe what is an organizational ombudsman and how it came to be, why organizations might want to have one of these, and then how do you do it? How do you do it from a legal perspective to make it work? How do you do it from an operational perspective? What kinds of issues do they deal with, and how do they deal with those issues? So that's really what the framework of the book is. I'm going to get you going, give you just a very brief Nichols overview of some of the history, some of the what is it, to kind of get you to the point so you can follow some of the other questions. And the history of it is that it kind of originated in Sweden. That's why it's a name that's kind of hard to pronounce. There's a fair amount of debate about that, but the original ombudsman was for Charles XII in the 18th century, early 1700s. When he was away from the country, it was somebody to kind of mind the store, if you will, in his absence. After the monarchy was overthrown and the parliamentary government came in 1809, the parliament had an ombudsman. And the concept there, and I won't go too heavily into it, was one of, it was a lawyer, legally trained person, who was an investigator and a prosecutor. And so in kind of modern society, we'd call that a special prosecutor. They have a kind of a mandate to be a watchdog, if you will, to kind of checks and balances. But that was in 1809, so it's really about 200 years ago. And it kind of spread through Scandinavia. Of course, it took 100 years to make the first jump to Finland, and then in the 1950s, it went to Denmark and Norway. And it came to the United States for those of you who are lawyers and lawyers of a certain age, like me, you may remember a very prominent administrative law professor by the name of Kenneth Culp Davis. Davis on Administrative Law was a prominent hornbook when I was in law school. And he wrote an article in 1961 in the University of Pennsylvania Law Review saying he must have had a sabbatical year. He traveled the world and was looking for new ways on how to deal with administrative issues. And the one that he found most interesting was the Swedish concept of the ombudsman. So he presented this in that law review article. And one of his observations was that if you took that principle and you applied it to the United States, basically American ingenuity would help it adapt to issues in America. And that's exactly what happened. In the 1960s, there were a series of law professors, Gellhorn, Rowett, and others, who took this concept in the governmental sense. And there was actually a resolution from the American Bar Association dealing with the 12 essential characteristics of an ombudsman. But it was a government ombudsman. It was this kind of watchdog, check and balance person who would be someplace you could go if you ran into kind of bureaucratic log jams and roadblocks. And there was even an attempt to get one through Congress, a congressional ombudsman. So it spread to lots of states and municipal governments at that point. And that really is kind of the model for what we now call the classical ombuds, which is a government official. Sometimes they have subpoena power, they do investigations, they issue reports, and they're really this kind of independent, maybe not prosecutor, but investigator. So somewhere along the way, they lost the prosecutorial function, became investigative. So that was how it started. But by the 70s, again, people of my vintage remember what the student riots were like, the student campus unrest. And what happened was the concept was applied in the university context in the 70s, and became really pretty widespread in the 70s, to deal not on an individual issue basis, but for an administration to deal with groups of students. And so that's why we had the ombuds in the university setting. And over time, what happened was it morphed into something that dealt with staff or faculty and individuals, not groups. So it kind of took on its own life. And I'm being kind of very general here, but in the 1980s, and this is when I first got involved, we now had in corporate America a whole series of crises. And if you follow this through, and I do a little bit in the book, you can see that it's a recurring theme of kind of scandal and investigation and response. But in the 80s, there was procurement fraud scandals. So you had the $1,000 toilet seats and the $500 hammers and all of this. And so lots of the major defense contractors were under investigation for procurement fraud scandals. And out of that came something called the Defense Industry Initiative, which was a consortium of about 17 of the largest defense contractors who came together to articulate principles that would be that they would endorse for how they governed their affairs. One of the things that came out of that as well was a presidential blue ribbon commission headed by David Packard of Hewlett-Packard, appointed by President Reagan, called the Packard Commission, and it recommended greater corporate self-governance as a way to help deal with these issues of fraud. And one of the recommendations was there needed to be ways of raising issues without fear of retribution, including an ombudsman. One of the clients that hired me in the late 80s had created their ombudsman program as a direct result of DII and the procurement fraud scandals. So you have this in the business setting, a function that was called an ombudsman that's different maybe than how the academic ombudsman originated. And there were different organizations, and they gradually came together surrounding certain principles. And those kind of core principles of what an organizational ombuds is, and that's what my book is focused on, were independence, neutrality, informality, and confidentiality. And the idea is that you needed to be independent because they're not the advocate for either the employees or the company. They're neutral in that sense. They're there as an additional resource. They're set up to be totally independent, even though the ombuds person may be an employee of the company. So typically they would have a charter or some operational guidance that would create that informality. The idea would be that they are there to help people coaching, options. They're not there to do investigations. They're not there to issue reports. They're not there to take sides, but they're to help people solve problems or to raise issues. And the confidentiality was seen as the critical piece, because if you were not confidential, why would people go to the ombuds as opposed to a compliance officer or HR or some other more formal channel where you could raise issues? So the benefit of the ombudsman was it was off the record, and it's where you could get guidance before you had to go anywhere else, or guidance that might answer your questions or get you information, so you didn't have to do something else. That was the premise there. So those are the key issues on which an organizational ombuds is premised, and that's really the context in which I've dealt with them, because as Jennifer said, I have represented organizational ombuds in major corporations and universities, national defense labs, and other kind of major institutions across the country. And that's the model that they typically will choose. There is another type of ombudsman, and that is the advocate ombudsman, like a prison ombudsman or a nursing home ombudsman. And I don't know, let me just get a sense of you. I don't want you to tell me what your issue was with the ombudsman, but have any of you ever dealt with an ombudsman before? So nobody here, okay. Yeah.
It was a permit ombudsman for a large trash energy facility.
Okay.
And so it was just helping different departments with permitting.
Okay, so it probably was in that sense more options and dispute resolution rather than an advocate for a particular side.
They were supposed to be an advocate for the applicant to get through
Okay,
that process.
all right.
But it was an employee of DEP.
Okay, so it was a government employee. Okay. Well, there are different models. That was my point. There are different models. In ombuds, when I prepare witnesses for depositions, I always say be careful of those elastic words that you may take one way and that somebody, once you respond to a question, can use in a completely different way. Well, there's no more elastic word than ombuds because it covers so many different kinds of models and assumptions, and that's part of the reason why I wrote the book, because I thought it would make sense to articulate what are the critical components of this organizational ombuds model that I was focused on, and how all the pieces fit together to get to the confidentiality that I think is so important to have. So that's kind of a very quick drive-by of the history of it. Yeah, please, go ahead.
Organizational ombudsman fit within an organization? Who is he or she reporting to?
Well, that is a terrifically good question. And the question was, who does the ombudsman report to? The best answer for that is typically the CEO or the COO, the senior management. There are places where they try to slot them under a compliance officer or HR. I think that's not the best way to do it, because how do you then demonstrate that you have structural independence? I mean, it can be done, but it's harder in the sense that you still have this perception of control. But the idea is you need access at the most senior level because there are issues. You should be able to get access to records and information and documents throughout the organization, university or a company, and that you don't disclose who comes to see you. You don't disclose, what the issue is, but you sometimes can, obtain additional information, and so you need that access. One of the great benefits for an organization is that an ombuds, because their individual counseling, if you will, is confidential, but the pattern of the types of issues that are coming before the ombudsman don't necessarily have to disclose who the individuals are. An ombudsman is in the terrific position to give trend reports and overall pattern issues, feedback to an organization. I mean, one of the simplest ones might be, every time we get a bunch of new MBAs, we get a spike in this type of behavior. And so maybe it makes sense to do another day or two of training, on some of these issues. I mean, that's the kind of the systematic type of issues. Or, we have a lot of, management changes at this facility. We're getting lots of feedback on issues. You're not disclosing anything that anybody said, but you're kind of talking about the larger questions. So if that's what an organizational ombuds is and how it kind of came to be, the next question I really tried to address, and I'm going to kind of go through a little bit on this, and then I'm going to try to see if you have any particular questions, because this really was a good question, is why would an organization have this? In my view, is that major organizations, and I know at least Harry used to work for a very large company, and I don't know whether the others of you used to have worked for large organizations before. But very large organizations are, they have departments, they have structures, they have other things. But in modern society, we have lots of diversity, we have lots of issues. And so when I looked at the case for why organizations should have this, it was really a three-part analysis, or fourth part, I guess. The first part is what I call the forces of change, and that is what's happened literally in our society. The second part is kind of what happens from the law. And the third part is kind of the inadequacies of existing structures. Now let me kind of go back. And then the fourth part, of course, is I think an ombudsman helps fill the gap. But in terms of society, and I go through a bunch of data. This was the hardest part. I'm a lawyer. I'm used to representing clients. I'm not used to doing social science research. But I've just felt some social science research was very important for this. So when I looked at this kind of forces of change, who we are today in the 21st century is fundamentally different than who we were 40 years ago or so. And yet I think sometimes our outlook was shaped then and continues to today. So for example, one of the statistics is that in 1950, the United States was 90% Caucasian. And by 2050, it would be less than majority Caucasian. And when you look at the kind of demographics of the various racial components of that, what you find is the Asian component doubling and the Hispanic component even more than that. So that right now, or soon, by I think 2020, the Hispanic component will be about 30% of the population. That's a radical change in terms of who we are and how we go about it. And that plays out in every segment of the country. It's not just I'm a New Mexican originally. It's not just in the Southwest. I think Connecticut, for example, has maybe the 6th highest Hispanic population in the country. Something extraordinary like that. So, and you look at any organization and you'll see that sort of demographic change. You have people from all over the world, all kinds of different cultures. And it's not just different cultures or different races, but you have a variety of other pressures on organizations. The role of women. I mean, I have statistics that talk about, what percentage of women were in the workforce in the 50s versus now. And if you look at the statistics now, women are outperforming men at virtually every level of educational accomplishment and are making their ways to the highest levels of organization. With that often comes different styles of management and leadership, different expectations, and different issues that kind of give rise to conflict. Generational issues. People in the baby boom generation kind of all came in together and are kind of holding on tight in lots of ways. That raises issues with generational pressures. A second force of change that I thought was just extraordinary, but when you really look at it, you see the impact of technology. I mean, we all know about computers and that sort of thing. But just to give you two little vignette statistics that I thought were really pretty remarkable. And this is old data. This is like from 2003 or 2004, so it's the best I could get. But it's 80% of the workforce, 80% work remotely or work with people who work remotely. So 4 out of 5. And I'm sure that would be greater today. And it's not just the workforce. I mean, I think you at a university, I'm sure you have people who are interacting remotely, electronically. You take an organization that's now a multinational organization and they have people all over the world. And in fact, the global scope is one of those, another force of change. But before I go there, I have one other statistic that I want to give you that I thought was just very revealing. And that is 1 in 4 workers, and this again is a little older data, it's about 5 years old. 1 in 4 workers is a non-standard worker, not an employee. They're part-time or contingent. And so the idea of being, even if you will, an employee has changed. So 25% of the people in the workforce are not employees as such, or part-time employees. And with that, and we all know exacerbated over the last couple of years, is the impact of the economy and the kind of new employer-employee relationship where, it's not kind of longevity driven, the kind of loyalty is not there, people are expected to change and move jobs. With that kind of bubbling stewing of society, our institutions are going to be affected because they draw their people from that society. Now you add the globalization piece. And again, I was struck by some of the statistics that show the power of our large major organizations. And one that I just thought was mind-blowing, that's all right, is I think there are 63,000 multinational corporations. This is, from the East India Company era where there was like 2 or 1 or something like that. But 63,000. But the largest 1,000 multinational corporations account for 80% of the world's industrial output. So the top 1,000 multinational corporations account for 80% of the world's industrial output. So we have these corporations that have 50, 100, 200, 300,000 people. Walmart probably has, I think, over 1 million employees. They're looking to hire 60,000 employees just to handle the spring rush because of how tough the winter is. And you take this kind of large industrial mass, spread it around the world, and you have people from different cultures interacting remotely, and companies, and Ben Heinemann, the former general counsel of GE, wrote a great little book about kind of essentially values-driven companies, and how to be a good values-driven company, you need a worldwide code of conduct. You need worldwide values. But how do you deal with, if you're a worldwide company, how do you deal with the woman who calls the ombuds? And this is one of my examples. I'm not sure I put it in the handout that I gave. Who calls up and says, my boss just called me into the office and says, I can see you're pregnant. I know you're not married. If you're not married by the time the baby comes, you can find a new job. Now that would be illegal in this country. It was contrary to the company's code. But she could have gone to everybody in that company in her country and had a deaf ear. So, you know, the concept of checks and balances and where does somebody go with real world problems like that in a multinational context is important. So I think the forces of change, with the change in society, the technology, the global reach of companies, is what provides the substrate, if you will, for the rationale. Yes.
Chuck, are you aware of situations where a worldwide company needing a worldwide code of conduct opted not necessarily for a sort of Western kind of modern code, but maybe opted for something that in some ways would be inconsistent with values and even the law in the United States, but that actually adopted that as the corporate code? And how?
Not as you have phrased it. I'm aware of the opposite. I mean, there's a big question with you know, equal rights, you know, women, but also gay, lesbian issues, and if you want to have, you know, a workforce that is attractive in certain companies, and you want to have a company-wide set of rules because all of these people are interacting globally, you need to impose that on other standards. So often, you know, it's the United States that has led the way, not always, and there are issues like privacy, where the EU, for example, has very strong views that are really kind of counter to some of the American views on kind of being able to report on other people and concepts of privacy. But if
do you see that values reflection different based on the kind of the country of origin? I mean, I can see that it might be more universally if it's a U.S.-based company applying that one way internationally, but if it's a Asian-based company, it might be slightly different.
I'm not
and
really
that may
sure. I mean, I have
in the whole, therefore the whole structure of problem resolution, conflict resolution, ombuds, and where it fits within the organization, just because of the cultural mindset from which it emanates.
I actually helped a Japanese company, a large Japanese company, set up an ombudsman program. Adapted there. Their U.S. component wouldn't do it, but they felt that it was important, and it really kind of runs counter to some of the, at least I was told, cultural issues there, but they felt they liked the concept, and so they decided to do it. But the difficulty, I mean, it gets into questions of like a compliance officer. I mean, that is a concept that kind of has only been around for about 20 years as a result of the federal organizational sentencing guidelines. One of the privileges I had along the way was to participate on the advisory group that helped revise the federal sentencing guidelines in the early 2000s. But within a period of about 10 years, you took a concept that 15 years earlier had been virtually unheard of, not entirely, but almost unheard of. And within 15 years of the federal sentencing guidelines, it is a worldwide standard piece of furniture in every corporate suite.
Is it possible to have a global top where there's common interest and then segmented according to the culture?
Oh, I think that's what in fact happens now. I think the pressures are to the contrary, but you know, ombudsmen are not in most major corporations now. I think most major corporations are debating that issue, you know, at what point when you have 20 or 30 subsidiaries, and the subsidiaries are largely confined to kind of, you know, country geographic areas. At what point do you kind of roll them in? One of my clients is a major Midwestern industrial company. When they decided to do I mean, they have, you know, 200,000 employees or something like this. When they decided to create their ombudsman program, they did it for North America first. They did it for South America and Mexico second. They did it for, I think, China third, and now they have one for India, and I'm not sure they've taken on Eastern Europe yet, or Europe. So it's an interesting way that they've gone about expanding it. But if that's the substrate, if you will, the pressure on that substrate, the kind of society and the organizations, I think comes from the law. And I won't bore you because I know some of you are not lawyers, but I have been involved in, at a kind of national level dealing with the federal sentencing guidelines. I've done federal procurement fraud investigations and that sort of thing. I've also handled civil rights cases, as Jennifer said. I've done lots of different kinds of things. So I have a sense of that process. But whether it's kind of corporate governance, whether it is from criminal law, or whether it is from employment law, the developments over 40 years from each of those have kind of converged. And the way I would describe them is each of them from their own perspective and their own kind of course statutory or whatever, from Sarbanes-Oxley to Title VII, have put pressure on organizations to do the right thing, not to tolerate misconduct, to investigate misconduct, and to take corrective action. So we now have much more vibrant, strong investigations, HR departments, compliance officers. But what that has meant is they're not going to look the other way. They're going to be serious about it. They have to take action. And there is a body of research that says that the more seriously you take that, the greater the barrier to coming forward with issues. Because now somebody can't just go to the compliance officer and say, let's have a discussion off the record. What do you think about this? What the compliance officer now knows is imputed to the organization for a whole host of reasons, good reasons. And so whatever that compliance officer knows, or whatever a supervisor knows, he or it has to act on. And that means an investigation. That means turning on the machine and cranking out whatever the process cranks out to get to the result at the other end. So if there are greater barriers to coming forward, how do you deal with that? And so the third part of my kind of examination as to why, and I'm about to stop here and then try to answer some questions, is, okay, well, how have we dealt with this as part of our institutions and society? And on that score, we have these functions. We have compliance officers. We have HR people. Well, I call those the police because they have official business functions. They keep records. They have a mission. They're accountable. But also, by the way, they're a silo. HR issues go here and compliance issues go here. And so what do you do if you're an employee and you don't know what it is? Or what if you're a person from another country? You don't necessarily think in those terms. How do you know where to get on the merry-go-round, so to speak? And also, what you say to them is going to turn on the machine, as I call it. So there's a limitation there. If you look at what most major corporations have done, and this comes out of the federal sentencing guidelines, it comes out of Sarbanes-Oxley, it comes from a variety of kind of corporate governance initiatives, most companies now, as kind of best practices, have hotlines. You have a problem, call the hotline. Well, the problem is, when you look at the data, 1 or 2% of an employee base may use a hotline, and those who do only result in 1 or 2% of the issues that come to the hotline being compliance issues. So you have this huge outsourced industry that's been built up on, I think, a faulty premise. That what's driven it has been the compliance, fail-safe, but how it's used is, I hate my boss, or this or that. Issues that I think are far more susceptible to a listening person who's knowledgeable about the organization, who can offer options and coaching and counseling, not you report it and we'll investigate it, which is the assumption of hotlines. And so you look at the data for hotlines, and I think they're an incomplete solution. And then, we also have whistleblower laws, and we have over 200 whistleblower laws in the country. And if any of you heard Harry Markopolos in the Bernie Madoff scandal, he was saying how he'd gone to the SEC and tried to report on all of this, and nobody would take him seriously. Well, as a result of that, we now have the new Dodd-Frank bill, which has created an incentive, a financial incentive, much like the False Claims Act. I don't know if any of you are familiar with that, where if you report misconduct directly, you can get a piece of whatever the ultimate recovery is. But when you look at that, and I've actually done some more writing on those issues, they fail to solve the problem too, because, for example, virtually all whistleblowers virtually everybody perceives that whistleblowers get screwed. And in fact, most of them do, one way or the other, because the law can't really reach peer retaliation. It can't really reach the cold shoulder or the missed assignment or the kinds of things that happen. It can, in broad brush, prevent somebody from getting fired, but in the book I go through the TARP legislation, which had this very elaborate whistleblower mechanism with the Inspector General and issuing reports to the company and the supervising agency and that sort of thing. So are you really going to be a whistleblower if it means, even if you keep your job, if it means reporting on your company and so put the company out of business or everybody risks their jobs? I was telling Professor Brown shortly before we started here that there was this fascinating article in the New England Journal of Medicine last May that studied successful false claims plaintiffs in the pharmaceutical industry. So I think they identified 26 people who had recoveries ranging. This is, if you report to the federal government, there's an involved process. Fraud and misconduct in dealing with the government, you get a piece of the recovery that the government gets. But it may take years to get it. I think they studied 26 people who had recoveries from $500,000 to $40 million. So you'd say, these are the winners, if you will. Well, virtually all of them said they wouldn't have done it again. The time for recovery was, I think, an average of 5 years, maybe the longest was 9 years. Of the 4 people who were outside the pharmaceutical industry, I assume lawyers or accountants or consultants or somebody like that, all of those were still in their original business. Out of the 22 who were insiders in the pharmaceutical industry, only 20 were still employed in the pharmaceutical industry. You know, forget whether they were still employed for their company. They reported because of spiritual, personal ethics reasons, not because they were going to get some money at the end. And yet the personal costs that they describe are really pretty severe. Pressure exerted against them by company in response to the complaint, 18 out of the 22. They put their career on the line, devastating personal financial consequences, such as losing their jobs and homes. A third of them had domestic difficulties, divorces, and then they had health issues, shingles, stress, and other things. So I think the whistleblower model of, you know, you blow the whistle and we'll protect you fails, because you really can't protect them from certain kinds of real response. And it, you know, for example, just imagine you're the whistleblower and you've now not gotten a bonus, your boss hates you, and you go home at night and your spouse says, honey, why are you doing this? I mean, that's the problem. So now, with that, let me give you one little vignette to show how all of this comes together, and then I'd be happy to answer questions from the examples to legal issues or whatever you'd like. This is not every day. Most of the issues that come to an ombudsman are pretty normal, everyday issues. You know, how do I deal with an evaluation? How do I deal with somebody who's making inappropriate comments? How do I deal with somebody who may be doing something that's inappropriate on their own computer? But every once in a while, and for virtually all ombudsmen, you know, at least once a year or more often, you get a big one, and it's a big one that helps the company. And here's an example. Somebody comes to calls the ombuds and says, can you help me find where our company policies are? And of course, they're all online, and the ombuds knows that the question asked first is often not the real question. It's just the test question. And so the ombuds says, well, here, let me show you. You know, go to this site on the computer. You can look here. And it turns out the policy they're looking for was the kickback policy, or the anti-kickback policy. So the ombuds now is in a position to say, I'm not the reporting channel. If you have concerns about whether somebody's taking kickbacks, I don't investigate, I don't report. But I can tell you that the company takes this very seriously. I can tell you what the process is that the company goes through. They hire a lawyer to represent you. If you report it, they hire a lawyer to do the internal investigation. They follow the facts wherever the facts go because they take it very seriously. And if you have concerns, once you read the policy, call me back. I'm confidential. I'm off the record. We can talk about what your options might be. Well, the person does call back. And to make a long story a little bit shorter, it's not a person from the United States. It's a person from another country. The company is a regulated company. The concern was by a young person against the boss. Are you really going to take on your boss? Are you really sure that you have all the facts? Are you sure that you really are going to take on entrenched power that way? So by the time the ombuds gets to this other country to speak with this person, the person has already quit the job, found another job, and because of that, felt a little more liberated to say, I'm not sure if I'm right or not, but here's my thought. So he was willing to let the issue come forward. Sometimes they let issues come forward even though they're not identified. And the big issue, I think, is not so much how do we promote whistleblowing, but how do we promote the resolution of disputes and raising of issues without having to make somebody be a whistleblower. That's the issue. But in this case, the person was willing to have the issue brought forward. They did the investigation. The boss was taking kickbacks. The company was able to discipline the boss, turn off the misconduct, self-report to the regulators, and it avoided an article that would have been on the front page of the financial paper there in the Wall Street Journal and a variety of other places. Not every issue is like that, but that's an issue that had you not had this type of a mechanism, would never have come up. Somebody would have walked away. And you know, I have a bunch of examples here that I handed out. I assume everybody got a copy. These give you a sense from the mundane to the kind of more serious. So, you know, with that, I've probably talked far too long. But thoughts, questions, concerns? Yes.
You said that if someone went through the formal channels such as HR or compliance officer, that there would be knowledge imputed to the organization.
Correct.
How do you avoid that when you go to how does an organization avoid that when you go to
Terrifically good question, and I have a whole long section on that. And the question once again is how, if going to an HR person imputes knowledge to the organization, how is going to the ombudsman any different? And for those of you who are non-lawyers, imputed means, you know, since a corporation has only agents, there's no kind of real person, it's not like me, they can only act through their agents. When does the knowledge of an agent kind of go to the company? And it involves issues of criminal law because, for example, a corporation can be in violation criminally of things, even though its agents are acting contrary to company policy, if those acts are imputed to the organization. And the answer to the question is one of how we look at what is apparent authority and authority. And there's a body of law that says if you have express authority to deal with certain issues, so that HR has a job function that does this, compliance has a job function that does that, they are agents of the corporation for that purpose. The law, there are Supreme Court cases that deal with supervisors. What supervisors know are imputed to the organization. From the perspective of the ombuds, now we kind of come full circle. The principle here is that the non-imputed notice comes from the structure that you've set up. So if you set up someone with a charter and you say, we expect you to abide by the Code of Ethics and Standards of Practice of the International Ombudsman Association, and you are not, you're independent, informal, neutral, and confidential, and you have a charter that says you are not authorized to accept notice of claims, and you have everywhere that going to an ombudsman may be helpful, but if you have claims against the company, you need to go to one of these designated channels. then I think you've got a pretty good argument. I've litigated those cases. We don't have a national statute. We don't have a body of law that you can say is unmixed, that's absolutely certain that that's the case. But every time I've had to write a brief or have argued this, where we have it set up the right way and documented the right way, and part of what I go through in the book is, just that operational requirement, then I think you've got a pretty good basis to do that. And if you're confidential, and part of the first case that I had where I wanted to kind of represent this company was, okay, how do you protect the confidentiality of ombuds? Well, I kind of scratched my head at the time. There was only one case in the country dealing with ombuds confidentiality, and that was in Iowa, and it was taking a statute that gave confidentiality to a prison ombudsman, and a federal judge applied that in federal court under something called the Federal Rule of Evidence 501, which allows for common law, in other words, case-by-case development of privilege, which means, that there's a kind of a pass on kind of having to disclose this. Well, in a very well-established test and applied in the Second Circuit, which is where we are, it's called the Wigmore test on privilege. Were communications made with the understanding that they were confidential? Is confidentiality important to the relationship? Does that relationship serve a very important public purpose? And basically, is the benefit of preserving that confidentiality greater than the benefit of disclosure? And so we put together a brief and affidavits for this company that went back to DII. We went back to the Packard Commission that I talked about earlier. And we said, look, in all of the programmatic literature, we say the communications with the ombuds are confidential. We're independent, neutral, confidential, informal. We're not a notice, we're not an office of notice to the company. The defining characteristic of the office is the ability to have a confidential conversation off the record. Here we broadcast it everywhere. It serves a very important public policy because we now have presidential commissions, blue ribbon, white papers that say you need better corporate self-governance. We have the largest defense contractors in the country saying this is important for them. Since then, we have Sarbanes-Oxley and we have the sentencing guidelines and other things that we can point to, including the Uniform Mediation Act. But so you say all of that, and then the key thing for the court is nothing about the communications with the ombuds changes any of the underlying facts. So you can get all the facts, what happened. What you can't get is what the communication is with the ombuds, and that's off record. And I've done motions for protective order, motions in limine, which are kind of motions that you make on the eve of trial. Some courts have granted them. The first case was granted by Judge Cabranes, a Second Circuit judge now, when he was a district judge. Other cases, I've had judges shake their heads and say, well, Mr. Howard, I'm just not sure what you say is correct. I don't have this. But I often will say, look, this company has spent $25 million over the course of many years. Tens of thousands of people have used this to resolve their dispute very effectively. Somebody who used it shouldn't be able to come in after the fact and destroy it for everybody. We say, I try to, when I advise clients, to draft it so that we say, this program is made available to people with the understanding that communications are confidential. So we have an implied contract basis. You took it subject to these terms, and now you can't come in after the fact and undo it. So I've had judges granted on implied contract, on privilege, and I've had judges say, well, I'm just not sure that there's a privilege. I'm not sure that there's an implied contract, but Mr. Howard, I'm just not sure this is relevant. And I smile and I say, okay, I'll take that to the bank, because that's an even safer position for the judge to take, because it's a reviewable on appeal on an abuse of discretion standard, which means he's got more leeway there rather than deciding as a matter of law that it's privileged or this or that. So that's how we do it. Now, I can't say that this is so clearly established, but I think, and part of the passion that I'm talking about here, is that there is something missing in our society with the pressure from the law, and you look at the nature of these large organizations. I just think we need a different piece of furniture, and it would be an ombuds. It's not going to solve all the world's ills, but it's going to help people resolve conflict and raise issues. Other questions? Yes.
I was just wondering if there's, if the results of the confidential conversation results in the ombudsman learning of a statutory violation or something that is criminal in nature, at what point? And what the second part of it is, what if he so informs the CEO and no action is taken?
Okay. Fabulously good questions. Let me see if I got them right and correct me if I got them wrong. I'm going to repeat them for the. So the first part of it is what happens if the ombuds learns something where it may be important, harassment or discrimination or something others that maybe should be reported, and what happens if they report it ultimately to the CEO and nothing gets done. On the first issue, there are exceptions to confidentiality, and this is part of what I kind of lecture to ombuds. It's not necessarily what you say is an exception to your confidentiality. There's this little thing called the law that you have to deal with. So if a statute says that, for example, if there's child abuse or something like that, and you come within the scope of a reporting person, you're going to have to report that. So there are kind of statutory requirements if you're a licensed social worker, if you're a psychiatrist, psychologist, or medical doctor, or something in this role. Sometimes you have difficulties with dual functions in this. You may be a lawyer, you may have ethical obligations, but also you have, your programmatic obligations. Usually there is an exception to confidentiality for what is called imminent threat of serious harm. That comes out of a series of cases in California where there's a legally imposed duty to report where there is imminent threat of serious harm to identifiable third parties. There are cases that do that. Some of that's incorporated in statute. So you'd have to report that. So those, I think, are there, part of the landscape, but still not often needed. Or they don't come into play very often. What happens when you say something to the CEO and it doesn't happen? I'm not aware of that happening too much, but virtually everywhere you have a dotted line to the audit committee of the board. And one of the examples I gave in the little handout is what happens to, it's about halfway in, it's on page 237, the third example. Where does a vice president go with concerns about the president? I think that, yeah, there should be, here, take this. Part of the problem is the higher you go, the greater the risk of reporting. One of this little factoids that astounded me was for highly technical, scientific, professional, financial, engineering type organizations, national defense labs, scientific universities, that sort of thing. About 40% of the people who come to the ombuds are not low-level people who you might think have been victimized. They are first, second-tier managers who have lots of technical competence but have HR issues that they need to deal with. And what happens is the higher you go in the organization, the greater the risk of reporting. And you know how the organization treats people. You know where the bodies are buried. You know what happens. So where do you go? And so the higher up is often, more problematic. And here was somebody who saw a regional president acting in inappropriate ways at a conference. And where does that person go? It's the president, and he's a vice president. So how do you deal with that? And that's where you need somebody to talk to off the record on what the strategies are. What are the possibilities? How can you raise these issues? And here, essentially, the ombuds was given permission to go to the CEO, and the CEO then started an investigation without revealing where they got the information, where they talked to a broad range of people. So it never came out who blew the whistle. Yes?
Chuck, in the dispute resolution arena, there's been a host of proposed uniform and model laws: arbitration, mediation, collaborative law, consumer arbitration. You've raised a number of recurring thorny issues with ombuds. Has there been a move to develop a uniform law?
not a uniform law as such. I have drafted a law which we almost got through the Texas legislature 2 years ago, 4 years ago. So there has been some legislative effort. We got it through the House with no votes. We got to the last day of the Senate, and a union representative kind of ambushed us on that. It may be revived this session. One may not think that Texas is the most enlightened place for ADR, but I think it really is in lots of ways. It has some pretty progressive legislation in that. So the thought was maybe we could get something passed someplace that would provide some protection and then build from that. We haven't taken, other than there are a couple of ABA resolutions, American Bar Association resolutions, that have tried to identify certain issues. But there's lots of opposition in some ways. I mean, it's been my experience that when you deal with internal compliance people sometimes, or HR people, there's this kind of baseline sense that any issue that goes to the ombuds, we can deal with too. In fact, we should deal with it. So why do we need that?
I guess a couple questions that go at effectiveness from the organization's perspective and the individual's perspective at two different levels. One is kind of this high-level issue. Ombuds offices are often set up out of a sense of crisis because of some event. Historically, my understanding is often the first ombuds officers come from trusted position within the company. They've been kind of acting in that capacity. They become the first person. Sometimes they build a staff around them. That changes over time. The leadership that was there for the crisis changes over time. So is there kind of any attenuation or diminishment of the access, the entree, the authority that comes from a role without authority in so many ways over time, or have ombuds officers been in existence and professionalized to a degree where that's happening less?
More the former, less of the latter. The question is, when you set it up, oftentimes it's out of a crisis, and you get somebody who's very well respected, who knows the company, they fill the first role, but as time goes on and people change, does it become essentially watered down, and how do you deal with that? And I've actually seen it both ways, but more the former. And the lesson from that is the lesson of having it properly documented. So where you have a charter, where you have built into the job description requirements that they adhere to the Code of Ethics and Standards of Practice, where you have certain access rights, like to the chairman or the COO or the audit committee, that's where you tend to have more of a sustaining power. And if I can, just one last thought. So I have seen some organization go through 2 or 3 ombuds in that sense and come out just as well as they started. I've seen other organizations where the second person is hired at a pay grade less than the first person. And maybe some changes take place in reporting structure. And again, I think this is part of why having some more standardized was part of what motivated us to do this draft legislation, where you are articulating, what are the essential characteristics, who should they report to, as a way of counterbalancing that sense of powerlessness by this independent office against the corporation.
So that helps with the big issue, potentially high profile, lose the company kind of, or major leadership challenge. What I've heard in implementing employee systems design around the country in places that have ombuds is often from the very low level employee that has very minor issues, which are probably 98.99.5% of your calls of, where do I find this, what do I do, that's a sign of a successful ombuds office, but it also generates a volume of calls that then means that the employees feel that the ombuds office isn't being responsive in the way that they need to be because they aren't getting back to them in a timely fashion, or they can't get through to them. And so how do you do that in terms of the number of ombuds officers, the type of business, to make sure that it is responsive in the way that it needs to be and isn't overwhelmed by? what's coming forward?
Well, I don't have the statistics off the top of my head, but if, if my comment about 1 or 2% of the population base using a hotline is correct, and there's some more recent data said maybe 3% of 3%, meaning 3% of the issues that come to a hotline are compliance-driven, and it's at most used by 3% of the people. I think typically the ombuds offices are used by 5 to 10%, 4, 5, 6, 7% of the population base, so it's maybe double a hotline. But you raise a good question. I mean, how many do you need for 200,000 people worldwide? Where should they be? What are the issues? And as I've tried to articulate it, and as I've dealt with, I'm not an ombudsman, but the lawyer representing them, the challenge is much of what an ombudsman does is supply information that you could get elsewhere, but for whatever reason you don't want to do elsewhere. So, for example, one of my little vignettes, and by the way, all of these were true. I got them not just from my clients, but from other ombuds programs, was, where does the person go who says, do I really have to have drug testing? I'm not worried about it for the result. I'm worried about it because I don't believe that we should have to do this. But if you ask HR, do I really have to have drug testing? They'll say, 1, yes, but 2, you'll have a little check mark by your name because they're going to worry about you, right? I mean, that's just the way, even if they don't put a check mark, they're going to remember you. So you may get your random drug test here before too long. So how do you get information? I mean, another example was the probationary employee who, and this happened, in this period of layoffs, the company said, you've got to take furlough days, and you can take them whenever you want. Well, in his department, the boss said, you're going to take it here and now, but he's a probationary employee. It's absolutely contrary to company policy. Is this probationary employee going to raise the question? And so where does that person go? Now, maybe that's not, cosmic issues, but there are a lot of those, and it really goes to the heart of checks and balances. I've got one more I'll tell you about in a minute. So what the person is, went to the ombuds, without revealing the person, goes to the kind of company people, HR, I assume, dealing with the furlough days, and says, it'd be a good idea to probably have in the next newsletter a reiteration that the required furlough days can be taken at any time, and it would be inappropriate for supervisors to say, you can only take it at this time. So it's in an FAQ, frequently asked question type mode, doesn't point out anybody. It could have been anybody who raised the issue. That's a real benefit to the organization, I think. One of the other examples in the material that I gave you is, what do you do when, because of this new world that I'm talking about, you work for a local facility of a big company. All the people you know are at your local facility. You're not sure you're right, but you believe that the management of your local facility has got a business on the side using company assets. You don't know anybody anywhere else. I mean, yes, there's a parent corporation somewhere up there. How do you deal with that? You can't, there's nobody else that you know. How do you deal with it? And so it really goes to the question, yes, there are lots of mundane issues. I think the ombuds who are really good listen to crazy people with good issues, not crazy people with bad issues, people of all types with issues that kind of can't get resolved. But many times it's a question of sorting out the noise, focusing on a question, perhaps giving instruction on how you can write a letter, how you can have a difficult conversation, what might be a constructive way, role play.
Many ombuds offices have very good
materials yeah.
online for folks.
So, I mean, that's the benefit. It's soft stuff, but it really does make a difference, I think. Harry?
Question from the devils in the detail department.
Sure.
The noble goal of confidentiality. You mentioned I was with a large corporation where it would take about 4 hours for any fact to become widely known. Where does the ombuds sit? I mean, how do you, the people walk in and out of the office, does the ombuds share staff with someone else so that there'll be a secretary who's got half a confidential hat, half a non-confidential hat? How do those?
Perfectly good question. So the question is, how do you deal with confidentiality from the most mundane details to the others? one of the Connecticut companies that will remain nameless, and it's not, by the way, your former employer, that called me in at one point to deal with their ombuds program, had a person who was half-time EEO officer and half-time ombuds. And I said, no. You can't do it. You can't take one person who's got an official job to investigate allocations of, racial whatever, and have them be an independent neutral. You just can't do it. You cannot do that. So you can either not have an ombudsman, or you can kind of find two people. And I don't know what they did ultimately with that, but I did not continue with them. But to answer your question on the logistics, typically they have their own computer. They keep their data. They may be on the company server for their email. They typically will have an office that's out of the way. They're always kind of cheesy offices, typically, because they're behind the cafeteria. They're in a place where lots of people go, and it would not be unusual to see people there. They have their own staff. They lock their doors. They lock their file cabinets. Some of them actually empty of their own trash cans. I mean, and I have put together affidavits in my motions for protective order to recite those kinds of reasonable, I usually draft. In fact, I had a discussion about 2 weeks ago with a client, a relatively new client, saying, when you have your secretarial staff, they are not ombuds, but they work for you. I think you should have a confidentiality agreement that they sign saying, you are an office where you're bound by certain things attached to the code of conduct and standards of practice. You expect them to abide by this. If there's any question, they should come to you. The privilege is held, or the confidence is held by the office. So where I get a shot, I do address all of those kinds of devil in the details. And as Bill said, many times there are people, I don't think there's a magic background for this. I don't think you have to be a lawyer. You have to be a good listener. You have to be able to deal with people. Ideally, you have to be able to deal with somebody at the CEO level and the janitorial level. You have to, and as Rudyard Kipling said, treat everybody the same. And there are people like that in every organization. You know who they are because they're probably already, engendering a fair amount of confidence from people. So those are the personal skills that really can't be taught. People have them or they don't, I think. And so I think that's more important. You can be taught the essence of what the ombuds role is and how to, techniques and that sort of thing. But for the programs that do it well, they focus on that. They focus on training. They focus on the ombuds will go out and do kind of presentations to all new employees. They'll go out on the website with kind of periodic descriptions of who their office is and why they're there. Typically, they try to have a range of genders, ethnicities, geography, because different people kind of respond to different people. So, yes.
It sounds as if this is something that only fairly large organizations could afford. Maybe only very large organizations would have a strong incentive to create. But I'm wondering whether it's, is it something that could be kind of shared or outsourced in a way that would make it possible for smaller organizations to have someone who's an ombuds, but sort of not in-house, but kind of collective ombuds who they share with 3 or 4 or 5 other companies, and so that would really be putting the emphasis on the independence, I guess. And I wonder if anyone's ever discussed that as a way of making it workable for a wider range of organizations, or if there's just essentially that's so inconsistent with the ombuds.
No, I have thought about it. I do know that there are some out there doing that.
I actually know some folks who do that, and I have somebody who the first company they contracted with was a relatively small company. The CEO bought into the whole thing. The first call they got was a complaint that one of the other secretaries was having an affair with the CEO. And it turned out to be true, and that was the first thing they had to go to their client and say is, you've got this problem, and it's you.
sometimes the issues are big issues. But yes, and I have advised some, it hasn't spread because even for the big companies at a time of kind of intense economic downturn, everybody's squeezing costs. So if you talk to compliance people, if you talk to any non-revenue producing function, everybody's getting by to do more with less. So, and Ombuds is kind of at the end of that because it's a relatively new function. And so I think that is one of the dynamics. I have actually helped set up an ombudsman program for a national franchise chain that was kind of modeled on the same thing. You increase greatly your independence because now you have a contractual separation, you have different parties. It raises questions of insurance and indemnification. It raises questions of HIPAA and privacy and access to company records. It raises a variety of questions because what makes an ombuds really effective is having access to information where they need it, access to talk to people. So it can be done, but a smaller organization probably has less discretionary money, and you don't have the people who are on the inside who really know the culture. I mean, what really can make an ombudsman very good is somebody who has spent 10 or 15 years, who knows that culture, who knows that, you know, maybe you go to this person in HR as opposed to this person in HR, or you know, this is how we can do things here. That's the value-added piece, where you're an external source. And I've seen some of what Bill said. You fight battles with, how often are you going to be on premises? How often can you be visible with employees? Is it only a sham? Is it real? All of those are legitimate questions, and I'm sure the practice varies. But I think where it really is necessary is for organizations that have 5,000, 10,000 or more people, because now you have lots of people. It's kind of outside the scope of, you're dealing with people really you don't know. I mean, you just can't know them, and you have multiple locations, and that's where you start losing something in terms of the culture and the adhesion of the organization.
I'm a little bit confused. There's when some of the agencies merge or even corporations merge, there are companies that do facilitation to enable the merger of the cultures, and they're part of a facilitation orientation. How does that, is that somewhat of an ombudsman or?
Well, they may have some of the functionality of, I think, facilitation more than anything. How do you meld different cultures? How do you bring people in? How do you surface that? But that's kind of episodic, meaning, it happens when that merger takes place. The ombuds function is kind of, day in and day out issues. It's just like mediation or a variety of other things. Some of the skills that are used are the same kind of skills. So there are times where, an ombudsman may get permission and go to a supervisor, with an issue. There are times when an ombudsman may, try to give an employee, coaching or role playing on how you raise issues or how you could have a conversation.
Is there particular training, or?
There is training for ombuds. There's an International Ombudsman Association that does Ombudsman 101 3 or 4 times a year. They have advanced courses in that. It's more focused on the ombuds function. There are mediation and other types of training programs that often give you the kind of skills that are very helpful skills to have. But this is targeted just for the ombuds.
One question, maybe it's too broad to even ask it, but
It may be too broad to answer, but you can ask it.
the skill sets, frequently the same skill sets is a neutral in a transactional dispute. Last week we heard a speaker about consumer disputes, specifically FINRA disputes, and the question was, is the process that's there, an arbitration, a mandatory arbitration process, sufficient to overcome the frequent criticisms of consumer arbitration, contract of adhesion, it's not fair, etc. it seems to me that while there's a sharp line between those transactional consumer disputes and the organizational ombuds, there's an awful lot of similarity between what goes on. And I see new models emerging. I think of Ken Feinberg as one person essentially being within the organization, but not handling internal disputes, but external disputes. It's kind of a blend between the ombuds and the arbitrator. Can you envision another process that might be that would come from the ombuds roots that would deal that could help address some of these consumer criticisms of consumer arbitration and help the consumer find a better way to get resolution of an issue? There's a lot of similarities. They're recurring disputes, same sorts of disputes, a common entity, in one case an employer, in one case an external organization, but a lot of common elements. Can you envision any sort of a melding of those processes to deal with the consumer disputes? I said it was a broad question.
Well, it's a very, you can ask it, and I'm not sure I have a really good answer, but I can envision, let me back up just a little bit. The role of the ombuds is not necessarily to adjudicate.
Right.
It's to help identify, surface, resolve, provide information, counsel, coach, call it what you want. It's really kind of an off-the-record resource. So in that sense, if you take that as part of the understanding of an ombuds and now apply it in your consumer situation, as I understand the issue that you're describing, it's that you have lots of consumers with repetitive issues dealing with the same organizations and a perception that the adjudicative model doesn't serve them well. And in that sense, there are a couple of responses to that. It may be that you need a broader variation in who or under what terms the adjudicators are picked and how they come to bear. So I don't know, and I unfortunately was stuck in court last week and could not get here. But it could be that the people who are doing those, are picked by FINRA or picked by whomever, so that a big part of their income comes. That's a structural bias thing. If they're dependent on that organization for their business, it's hard for them to take on that business. Maybe there's a counterbalancing consulting, counseling, supplemental arm for consumers. So it might be, without being the advocate for those people, here's some information that can help you. It may be that there's just a role for some sort of advocate, for them, like a model that is applied in the utility context is that there is, an applicant or a utility and the regulators, but there's something called the Consumer Council. So there's this kind of public interest representation body that has, can be aligned with either side on occasion. There may be a variety of models. Let me think about that, but I'm not sure because in the securities model, it's adjudicating or resolving these issues. It may not be quite analogous.
Are ombuds offices more effective when they are part of organizations that have more robust services and choices around conflict resolution, compliance, HR, so that the assets that are there for the ombuds to direct people to and to supplement what they're doing?
Yeah, I don't know that I know that. I think where they're really quite effective is where you don't have the internal turf battle between compliance and HR. There are some places, and in fact, the fellow who was the chief vice president of business practices at a major corporation has spoken with me as one. Initially I think he was very reluctant when I first became involved. But ultimately he said, this office helps us do our job much better. And in a larger sense, it really does, because if the premise is that there are people, and the data supports this, there are people who are not going to come to you with issues out of fear that they're not sure, they're not willing to take it on, they're not willing to be a reporting channel. And this helps you get more issues in the door. It really does help you, especially the ones that, of the ones that come to the ombuds that really are compliance that you need to know about. So his view was it helps you. An HR person, I've had clients who say, you know, some of the people in HR routinely send people to us. Not that they have to come, but they say you may benefit from this. And in fact, HR people come. So, you know, I'd say they thrive best when you don't have the turf battle. You know, when the ombuds understands I'm not trying to be a court of review for HR decisions. I'm not trying to, you know, do my own investigations to supplant the compliance. And those other functions say, I get it. You know, I'm going to be the compliance or the HR. These people can help me. And yet, you know, occasionally they will meet, but you do have appearances and you have to keep the separation. Oh, more questions. Okay, sure.
I have a similarly general question, I guess, that kind of goes to some of the criticisms in the kind of bigger public policy debates about alternative dispute resolution, right? So the idea that, you know, one of the problems with ADR is that it sweeps conflict under the rug. It prevents the public from monitoring issues in which we have a public interest. It you know, keeps things out of court that really ought to be in court. I mean, you are familiar with that whole line of conversation. And I wonder the extent to which ombuds programs could be subject to similar kinds of criticism. You know, just the extent to which confidentiality and independence, neutrality are unalloyed goods, or whether, you know, there's some sense, and so the second part of the question, which is much more specific and probably easier to answer, is whether you're aware of any empiricism that can actually show that having an ombuds program does increase compliance with the law, right? So that, you know, you could say it's not that conflict or misconduct is being diverted away from the public gaze, but that we are actually preventing misconduct, or we are addressing misconduct.
Let me address the second part first, if I can, the empirical studies. I'm aware of some survey data. One fact that comes to mind is that in a particular company, if they didn't have the ombuds people, 10% of the people who reported to the ombuds would have left the company, something like that. So if you look at it, it's not compliance, it's not misconduct, but it's the lack of a channel to raise an issue. And when you consider what it takes to hire people and to replace them.
Isn't there data out there that says 50% of the time somebody leaves a company it's because of conflict at work?
There may be, I don't know that. But that's a powerful statistic that goes to the issue of having a place where you can hopefully ameliorate some of that by surfacing issues. And again, my point is that there are people who won't come forward if coming forward means being public. They don't want to be the whistleblower. And sometimes it's just information, or sometimes it's just a perception, or sometimes the ombuds can kind of do the role play and they, you know, somebody understands, okay, I see what the supervisor is trying to do. Or you know, one of the examples, I think I put in the book, I'm not sure, but it was priceless. Person had been the subject of lots of complaints to the ombuds over a period of time in this organization. Ombuds was struggling how to deal structurally with this, and because you now have a systemic issue with this particular person. One day the person walks in the office and says, how do I stop being an asshole? I mean, that was like an epiphany. And so, you know, that greatly benefited. Now, maybe sweeping it under the rug, you know, who knows? Now, to get to your first part, I think the same criticism could be made for ombuds. Where I fight the battle is with employment counsel or compliance counsel who say, we are not comfortable having issues that come within these kinds of silo jurisdictions coming to an ombudsman and are not knowing about it. And I say, well, I think what you really want is whenever there are those issues that if you're going to be responsible for having to deal with it or not having dealt with it, you want it in those channels. You don't want it someplace else. So if you say the Ombuds is not a reporting channel and is off record, that actually helps people get there. And if you hire the right Ombuds people, they're going to give options to people so that they can get there. Now, it may get there in an anonymous letter that the Ombuds help somebody draft that gives them enough information where they can really do something with it. One of the examples that I gave in the materials here was the person, I may have mentioned this earlier, who wasn't convinced or was concerned that her coworker was fudging on her timesheets and cheating the company, but was not willing to report it to the supervisor because the supervisor was having an affair with the coworker. And so you can't go to the supervisor, and you don't want to go to some other person because they're going to say, well, why don't you report it to your supervisor? And you don't want to lie. So, those are the kinds of issues. But so from the company, you want to channel it there. But yes, if you resolve issues quietly and off the record, isn't that a good thing?
Jack, don't most ombuds offices track the calls and the nature of what they're about
They give some statistical reports.
So there's
right.
usually a statistical annual report,
Right.
which is centralized in a different way that does not exist for most ADR services that are rendered. Those are on an individualistic, usually confidential basis, so there's often very little aggregate data about ADR. So I would say that the reverse is probably true of ombuds, is that there's a greater awareness of not of maybe what's happening with each individual issue, but this kind of trend reporting is raised.
That's the real benefit to the organization.
It came out 10 years ago for academic ombuds that there was a lot of stuff coming up about, was authorship issues. And
policies.
And policies. So that becomes a bellwether. Okay, we need to develop policies around this, or we need to do training around this. So that kind of tracking acts as a bellwether, which helps address a systemic issue. Where if you're dealing with it on a mediation by mediation basis, unless you're going to the same mediator and they turn around and say, I've seen 10 of these.
Yeah.
And that brings me back to the kind of beginning point where I said my particular topic and my focus is really a structural one. I mean, yes, it's theoretical in the sense that I think there's this role that would be useful for institutions to have, but it really is kind of structural in that sense because it is recurring, it's helping people in an organization. It's not like, a case where you have, this versus this, or a mediation where you have kind of two parties and it's focused on the resolution of that issue with techniques and processes. This is a more multivariate process, I think.
There are statistics out there that will show what companies spend to comply with Sarbanes-Oxley and now it's Dodd-Frank, and you can see from a percentage of revenue standpoint what it costs for companies in different industries to be compliant in those respects. Are there stats out there that show, as far as the organizations that have strong ombuds programs in place, like what percentage of revenue in general a company might spend on such a program?
No. I wish there were, but they're not. Part of the difficulty is, I think, any kind of occurrence prevention function has a hard time justifying kind of what's saved. Now, costs are another issue. I have in affidavits described how much a company spends, but there's no kind of standard that I'm aware of. I could probably tell you what I think will work the best, in a situation where you need outreach and you need FAQs and you need brochures in 29 languages, and they do this, where they have translating services, where they can, take calls and have confidentiality agreements with translators that can help them deal with this sort of thing. But it's not so widespread or so well established that they can do that at the present time. I'd like to see that over time. Yes.
Does an ombudsman rarely use legal counsel? Is it primarily the organization that looks to legal counsel for structure? Or who does an ombudsman talk to if they're in an ethical dilemma?
What? I mean, most of what I do is business and intellectual property litigation. That's what I do mostly day in and day out. But as I say, I've represented ombudsman now for 20 years. And my role is independent counsel for that office. And it raises a whole host of issues across the gamut of kind of what they do and what I do. So I don't represent the company, but there are situations where I will help a company set up an office and document it. But typically I am the lawyer for the ombuds. I'm the ombuds, if you will. And I provide counsel. And frankly, I've had this was a kind of major national defense outfit, a national lab, say, we're so happy now to have you because we can tell you what we really think. And they're your clients, so you can tell them. Whereas if we told them, would come across too heavy-handed or whatever. And sometimes, frankly, what was being told to me to tell them made a lot of sense. So we could have that kind of privileged conversation. So the really good programs get it, that there's a need for independent counsel, and because I've done this kind of all over the country with a variety of different programs, I can take a look at a brochure and I build in evidence. Part of what I do is I'm a litigator, so I'm used to handling motions. I'm used to citing things in briefs, so I'll write language that I want to quote when I get to the point where I need to use it. And I understand how I'm going to use it down the road. So I can do that pretty efficiently now. I think many of the cases I've read, many of them I've been involved in. So that's really helpful, and it's really good to have. It also is really good when you have like a deposition, and this gets very problematic. I've had company counsel call me on the eve of a deposition with a sobbing ombudsman in the corner, saying, I didn't want to have to tell them what the facts were, but they said I had to do it, and I keep telling them that they should call you. Well, the problem is, if you, as the ombuds, disclose all of your confidential information to the company, I can't go into court and say you shouldn't have to tell it to the plaintiff. If you have the company counsel in a deposition examine the plaintiff and say, and what did you do next? And the person says, well, I spoke to the ombuds, and the ombuds said this, that, and the other thing, and he says, and what did the ombuds say next? And so the company counsel has already probed everything from the employee about the conversation. It's very hard to come in after the fact and say, the communications with the ombuds are confidential. It makes a huge difference, and this is kind of what I do, is try to educate company counsel. If you, at the beginning of that deposition, were to say, the company takes the position that communications with the ombuds are confidential and off the record, I would ask you not to disclose any communications you may have had. And I had one case where this was exactly the issue. We knew, the company counsel knew that there was communication with the ombuds because something had been disclosed in production that said that by the plaintiff, or by the employee. So if the company counsel said, we believe it's confidential, I don't want to know, and don't tell me if that becomes an issue and we lose, I reserve my right to examine you on it, but I'm asking you not to tell me, then you've got both sides being equal. So there are times where it really is very helpful for the ombuds to have its own counsel. But as I say, look, we're on the same team, we just play different positions. So I'm going to have a privileged conversation with the ombuds, but it's in that capacity as their role, hopefully helping the larger organization. But some use me quite a bit, some don't use me as much as I think they should. But I think whether it's me or anybody, I was being facetious on that. I think it's very helpful for ombuds to have their own counsel, because in one of the cases, when the company tried to file the motion for protective order for the company and the ombuds, plaintiff's counsel said, well, how can you claim that you're independent when you have the same counsel?
Well, with that, I think we may be out of time. So,
well, thank you for the chance to come and talk. I appreciate it very much. Thank you.